I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introductory lesson on New England state courts. This lesson is the latest of many provided by NEFAC that explore state freedom of information laws. We want you to know how to access government information, and these lessons are the best place to start. If you haven't already, please check out our classes on state public record and open meeting laws, as well as the Federal Freedom of Information Act. Each class builds off one another, and they all collectively provide a curriculum you won't find anywhere else. All lessons are at nefac.org/FOI guide. They're also on our YouTube channel, 5 Freedoms. Before we begin today's lesson, a special thanks to everyone who is helping us make these classes happen. The Society of Professional Journalists Foundation, SPJ New England, the Rhode Island Foundation, and the New England Society of News Editors. We appreciate everyone's support. Now, to introduce you to today's instructor, Emily Sweeney.
Hey everybody, I'm Emily Sweeney from the Boston Globe and the New England First Amendment Coalition, and I want to thank you all for joining us for this webinar, which is brought to you by NEFAC. And now this session is going to focus on the state courts in New Hampshire. And with us is Greg Sullivan. He's NEFAC's president, and he serves as general counsel for the Union Leader Corporation. And he's going to give us a general overview of how the courts work in New Hampshire. So Greg, thank you so much for joining us.
Thank you for having me. So, as Emily said, today we're going to talk about the state courts in New Hampshire. And as the slide says, it's an introduction. We're not going to go too deeply into some of the issues relating to courts. This is more of a guide to the courts themselves. The Supreme Court in New Hampshire is our highest court. Has a Chief Justice, 4 Associate Justices. They sit until the mandatory retirement age of 70, which I think is a horrible thing. Some judges, to me, are really hitting their peak at 70. Hey, I'm 70. So I'd like to see that change, but that's the law now. It sits in Concord, and it is New Hampshire's primary appellate court. It reviews and decides all the appeals from all the state trial courts and from administrative agencies. It issues writs of certiorari, writs of prohibition and habeas corpus, and they attempt, and I believe generally they do, correct errors in trial court proceedings. They interpret case law and statutes and the constitutions, both state and federal. And they oversee the administration of all the courts in New Hampshire. In New Hampshire, unlike Massachusetts and other states, there is no appellate court between the Superior Court, which is the main trial court, and the Supreme Court. Massachusetts, we have an appeals court that handles most of the appeals from the Superior Court. Not so in New Hampshire. If you do not prevail in your case in the Superior Court, your only appeal is to the Supreme Court. In the Superior Court, we have jury trials in both civil and criminal cases. Generally, the types of cases the Superior Court are hearing on a daily basis include, as you can see, negligence, contract cases, real property rights, and other civil cases with a minimum claim of $1,500. Less than $1,500, you're looking at a small claims case in the district court. Anytime the damage claim is in excess of $25,000, the case has to be brought in the Superior Court. Those are civil cases. Criminal cases, the Superior Court deals with the serious crimes, that is felonies, narcotics, burglary, theft, aggravated felonious sexual assault, not to mention murder, rape, etc. By the way, I have to give credit to the court administration itself. Most of these slides, the information thereon, I've stolen from the court. But I believe it's okay to do that for educational purposes. Later on, I'll show you a link to get to the court's website to dig deeper into all these areas of the courts. If you're looking for an injunction to stop somebody from doing something or to force somebody from doing something, that's only the Superior Court. Appeals from zoning and planning board decisions, disputes over title to real estate, and petitions to enforce contracts, all in the Superior Court. Now, we have three types of courts in the circuit court system. The court that's busiest, and probably most of you are familiar with, is the district court. The circuit district court handles misdemeanor cases, criminal cases, including motor vehicle matters, which keeps them busy, small claims, as I had mentioned, landlord-tenant, stalking, and other civil cases, again, where the damage request is under $25,000. 32 of these district courts around the state. The circuit court also has a family division. Divorce, parenting actions, child support, domestic violence petitions, guardianship of minors, termination of parental rights, abuse and neglect cases, CHINs, which is children in need of services, juvenile delinquency cases, and some adoptions. Then we have the probate division of the circuit court, and that has jurisdictions over matters relating to wills, trusts and estates, guardianships, involuntary commitment proceedings, adoptions, name changes, equity matters relating to partition, that's partition of real estate, quiet title, trusts, and the Cypress doctrine, which is rarely seen in the courts. Cypress doctrine is when there's a nonprofit trust or corporation set up and it is, for whatever reason, dissolving, and it still has assets. The courts will step in and employ the Cypress doctrine, which means they'll direct those assets to a similar trust, a similar nonprofit organization. In New Hampshire, fairly recently, courts have developed drug and mental health courts. And boy, this to me is a model for the nation, not to mention the world, because I've found in my years of practicing both civil and criminal law, so many of the criminal cases are the result of alcohol or other substance abuse or mental health issues. So these new drug courts and mental health courts are set up again around the state, and they work with community-based treatment programs, but the offenders who are seeking to avoid jail time, and I must say that very few people who do jail time come out ready to provide more positive influence in the community than when they went in. So I think these drug and mental health courts are a wonderful thing. The people have to report to the court on a regular basis, and if they don't, they are facing jail time. But again, they're referred to treatment programs, and obviously the goal is to reduce recidivism and protecting public safety. And I must say that I think they've been very successful in I can't tell you whether it's been 3 or 5 years that they've been, when I say 5, it might be 10, but from my point of view, fairly new courts and just a wonderful innovation as an alternative to jail. We have family treatment courts starting in New Hampshire, only in selected locations now. But it's a program where a parent with an abuse or neglect case can participate when substance use is part of the case, or when a child is removed from the home, the program offers, as it says in the slide, a supportive team approach to increase the family's access to supports and services, accountability and recovery, and ultimately the goal of reunification of the family. So it's a partnership of the courts, the Division of Children, Youth, and Families, and the court-appointed special advocates, parent attorneys, substance use treatment providers, mental health providers, and other community partners. So this is a pilot program, but I think it's really needed and a positive approach, just like the new drug and substance abuse courts. We have in New Hampshire an administrative office of the courts, which supports all the judges, clerks, all the staff throughout the state. They handle the budget and they oversee all these various, communications, human resources, all the operations. And I've listed at the bottom Diane Martin, who's the director of the AOC, with her phone number. If you have problems, and we're going to get to trying to access the courts. And I'll put it to you this way, we've made a lot of progress in New Hampshire in making the courts more accessible for the public electronically, but we've got a long way to go. So I mentioned access to the courts. Here in New Hampshire, we're unique with respect to this Part 1, Article 8 of our Constitution. And this article applies to all governmental officials, including judges and magistrates. So what makes this unique is that, and I usually start my slideshows, I didn't today, with the Constitution, which starts off, we the people. We the people are the state. We are the government. So based on this provision of the Constitution, all government officials must be accountable and responsive. The public's right of access to governmental proceedings and records shall not be unreasonably restricted. This is extremely important, this part of the Constitution, because in New Hampshire we have Chapter 91A, which is our right to know law. But the right to know law does not apply to the courts, and it does not apply to the governor. It does not apply to the legislature. It does apply to all other governmental actors. But when we are looking for accountability and access to the courts, we get this through Part 1, Article 8 of the New Hampshire Constitution, the First Amendment to the Federal Constitution, and Part 1, Article 22 and of the New Hampshire Constitution. And as you can see, to me, this article is even stronger than the First Amendment, because it says free speech and free press are essential to security, to the security of freedom in our state. They ought, therefore, to be inviolably preserved. So between Part 1, Article 8 and Part 1, Article 22 and the First Amendment, we have the right of access not only to governmental proceedings, but to the courts. It wasn't until 2005, however, that the law was really fully developed in New Hampshire, because in this case, AP versus state, cameras were finally allowed into our trial courts and our probate courts and the Supreme Court. All our courts now, we have the right to video, film, and record. And the Supreme Court in this case said this access, our access to the courts, ensures that court proceedings are conducted fairly and impartially, and that the judicial process is open and accountable. And this access to courts is part of our common law, which came over to us from England prior to the Constitution prior to the amendments to the Constitution, the Bill of Rights. But always from day one, courts in New Hampshire have been open to the public even before 1776. A lot on this slide to show you. And our right to, like our right to free speech and free press, our right to access to the courts is not absolute. Closed proceedings, although not absolutely precluded, must be rare and only for cause shown, the two important words, cause shown, that outweighs the value of openness. And when the state attempts to deny the right of access, the state must show that that denial of access is necessitated by what they call a compelling governmental interest. It has to be narrowly tailored, the limit. To limit the public's access to civil trials, there must be a showing that the denial serves an important governmental interest and that there is no less restrictive way to serve that governmental interest. Again, that's AP versus state, but the Supreme Court of the United States, of course, has dealt with these issues. And in a famous case called Richmond Newspapers, the criminal defendant was asking the court to close the court proceedings. He said that he'd be denied the right to a fair trial if the public and the press were allowed into those court proceedings. And the Supreme Court outlined many ways that trial can be kept fair by, for example, voir dire of the prospective jurors, sequestration of the jurors, change of venue, number of different ways that the fair trial right can be protected, but also the public's right of access to the courts is protected at the same time. Again, AP versus state, there's a presumption that court records are public, and this is important, the burden of proof rests with the party seeking closure on non-disclosure of court records. They must demonstrate with specificity that there is an overriding consideration or special circumstance that is a sufficiently compelling interest which outweighs the public's right of access. Now, some of these exemptions, I'll call them, that would override our right of access, the public's right of access, and the press's right of access. And by the way, when I say press or I say public, to me that means the same thing. Some of them are very common sense. However, where you'll see a lot of litigation over closed records in courts has to do with law enforcement. And this is a statute that relates to affidavits in support of warrants, and this applies to an arrest warrant as well as a search warrant. But it says the person who's seeking one, obviously a police official, has to give an affidavit, and the affidavit has to contain all the facts and information which establishes probable cause for the search or the arrest to happen. But what's important is the statute goes on to say that after this search warrant or an arrest warrant has been served, it has to be returned to the courthouse, and they shall be a public document when the warrant is returned. And many times the law enforcement officials will ask the court to keep that warrant closed. And again, a common sense reason that they request and is granted is with respect to an ongoing investigation, so that witnesses or other suspects aren't tipped off as to what's going on in the potential prosecution. As I said, some of the exemptions to our ability to get into court proceedings or to get records from those proceedings are common sense. Grand jury proceedings, always secret. Juvenile proceedings, and when I say juvenile proceedings, I'm talking about what would be in an adult setting the prosecution for crime. We don't say that a juvenile is convicted of a crime. We say that a juvenile is adjudicated delinquent. Same thing, but the difference here is that the juvenile proceedings are secret and the records are generally secret. Adoption proceedings, we have no right to get into those. Department of Children, Youth, and Family hearings, closed. Termination of parental rights, closed. Now this next one, and the next two rather, the court has discretion. Generally, if it's a minor victim of a sex offense who's on the stand testifying, the courtroom will be closed. It'll be open for the rest of a trial, but that minor is going to have the ability to testify without the public and the press being there and listening. Civil commitment hearings generally are closed, although the individual who's the subject of the civil commitment hearing, a civil commitment hearing is when either the police or any individual petitions the court saying this person is a danger to themselves or to society. Those civil commitment hearings will be closed generally, but the individual has the right to demand that the hearing is open. So in terms of access, I said earlier that we've come a long way, but we still need help. The system is either set up or being set up so that all of us, and particularly people who don't have the ability to get in the car or other means of transportation and get to the courthouse, because we can always go to the courthouse and ask to see the records of a particular case. But we're headed towards a day where we can electronically, right now we can get some information on the case, but hopefully someday we'll be able to access all the records in a case. And you can click on this link to begin your search. And as the slide says, there's separate portals for attorneys, self-represented parties, and non-attorneys, meaning just John Smith in the public interested in a particular case. There's also ways for lawyers and self-represented parties to file their cases electronically. But I must say, the system, to me, is not yet perfect. So what I've tried to do is just give you a quick introduction into the different courts in New Hampshire and how we can access. It's important to remember, starting with the proposition that all government officials, including judges, clerks, probation officers, all government officials are our servants and agents and must at all times be responsive and accountable to us. Our proceedings are presumptively open, but as we've discussed briefly, there are obviously instances where the courtrooms will be closed. I will say additionally, attorneys in civil cases often seek to have particular pleadings or documents that they've submitted sealed by the court. Trade secrets is a common example of litigation where one or more of the attorneys doesn't want the information available to the public for obvious reasons. So for more information and to dig deeper into these issues, I've highlighted a few websites, NEFAC.org, of course, the court system itself, where I took most of that information on the slides, comes from courtsnh.gov. RCFP, to me, is a tremendous resource for anybody looking to learn about government and when we're able to access or not access governmental records. And the loebschool.org, the Nackey S Loeb School in New Hampshire, has free classes on these issues. I'll give a shout out to my friend Gilles Bissonnette from the ACLU in New Hampshire, who's going to be giving webinars at the Loeb School coming up on accessing public records in New Hampshire. So I think my time is about up. I don't know if we are set up, Emily, to take any questions in the chat room or not, but I will say, whether we are going to do that or not, thank you to NEFAC, to Emily Sweeney, to Justin Silverman, the executive director of NEFAC. And I have put my email address on this last slide because I'm glad to take any questions anyone may have on the issues we've discussed, or any issues relating to public's right to know what the government is up to.
Greg, thank you so much for joining us today.
Thank you, Emily. My pleasure.